Hello, everybody. This is Robert Smith with Friday Eldredge and Clark. I appreciate everybody being available and joining in on this discussion today. Along with me, we also have Katie Campbell, who is in our litigation group in our Rogers office, and then Blake Lewis, who's in our M&A group here in Little Rock. We have, along with a number of other folks in our firm, and I'm sure all of you have worked feverishly the last probably week and a half or so as the Paycheck Protection Program has been rolling out. It seems to, it does have an enormous amount of uncertainty still in so many areas, both on the borrower side and the lender side, and that seems to just grow by the day. You all, I'm sure, are aware that there was a frequently asked question, series of frequently asked questions released last night. You should have gotten, if you are, I believe all of the folks on the call would be signed up for our alerts, and you should have received an alert we sent out reviewing those frequently asked questions probably 30 minutes ago or so. So just be on the lookout for that. And also, before we get started, I would just point out that on our website at fridayfirm.com/coronavirus, you can find access to all the information that we have there. That's Tabitha, if you'll go forward a couple of slides, we'll show you where you can sign up if you're not receiving alerts, and also just to access the other information that we have on the website. Yeah, keep going forward there, and you can also, as with any Zoom meeting, you can put in questions in the chat function, and we'll try to get to those as we can. We also have, I think, 8 to 10 questions that were submitted ahead of time, so we'll talk through those before we really get going. But just for some background, so the CARES Act was enacted on March 27th. Since that time, as we worked through the law, and I know as you all read through it and tried to make sense of it all, there has been some guidance from the SBA. There were 2 information sheets issued on March 31 that were very limited in scope. And then I'm sure you're aware on the 3rd of April last week, an interim rule was issued, which gave a little more clarity. And then, unfortunately, with the frequently asked questions I mentioned that were issued last night, that was several of the items in there really contrary to what the rule says, and so it was a little bit of a different interpretation than we were expecting, and I think most people were expecting. The problem is made worse because, as you all know, so many applications were being accepted by lenders and submitted based on kind of maybe a misreading, probably a misreading by the SBA, honestly, of just how that calculation of payroll costs should work. So what we're going to do today is I'm going to turn things over to Katie, and she's going to get us kicked off and just talk through the basics of the law, what we know, and some things we don't know yet, and then turn it over to Blake. He'll talk through the forgivable piece, which is really the most important part of this whole thing. And then I'll take over near the end there and talk through some frequently asked questions that we are receiving, some open issues that we think still need to be addressed by Treasury or SBA. But just to give you kind of a flavor for what we see is still the main points that are uncertain out there. So Katie, I'll turn it over to you.
Thanks, Robert. Good afternoon, everyone. So as you said, I'm going to give an overview of the Payroll Protection Program and kind of what we know at this point. So the first question is, who is eligible to receive a forgivable loan? Tabitha, if you want to go to the next slide there. The only criteria really are that the business concern has fewer than 500 employees, subject to a few exceptions that we'll discuss in a moment. Second, that the borrower was operating as of February 15, 2020. And third, that the borrower had employees for whom they were paying salaries and payroll taxes in February of 2020. So with that limited definition, it really expands the scope of who would ordinarily be eligible for an SBA loan. So it includes certain nonprofits, including 501c3s and veteran organizations with fewer than 500 employees. It also includes self-employed individuals, sole proprietors, and independent contractors. The definition would also include any business that meets SBA's current size standards for 7A loans. And the SBA recently clarified over the weekend that faith-based organizations are also eligible for PPP loans as long as they are a 501c3 organization. That was kind of an open question last week, and so we've at least gotten some clarity around that recently. In order to determine whether a company has 500 employees, you use the count of full-time and part-time employees during the covered period, so between February and the time that you'd be applying for the loan. And there are a few limited exceptions to this 500 employee limit that I mentioned earlier. So for accommodations and food sector employers and for franchises, they are accepted from that limit. So basically, if a standalone location has fewer than 500 employees, they would be eligible to apply. In addition, the usual requirement that a business is unable to receive credit elsewhere has been waived, so that's not a requirement to apply. The SBA recently clarified a few other things about who is ineligible to apply. So that would be if you're a household employer, so individuals who employ nannies or housekeepers are not eligible. If an owner or a 20% or more owner is incarcerated, on probation, or subject to criminal investigation, or has been convicted of a felony within the last 5 years. Obviously, if you're engaged in illegal activity, or if you or any business owned or controlled by you or any of the owners has ever defaulted on a government loan within the last 7 years, or has obtained an SBA loan that is currently delinquent. So any of those would make you ineligible. A brief note about affiliations. The SBA has rules where affiliate entities are counted in determining whether your business has 500 or fewer employees. And the SBA has recently clarified that there are 4 tests that apply to the PPP for affiliates. So I've listed them there, and I won't go into too much detail on that, but at a high level, the first one is affiliation based on ownership. And so if a business is an affiliate of an individual or entity that owns or has the power to control more than 50% of the business's voting equity. And the SBA also considers minority shareholders to be in control for purposes of this rule if the individual or entity could prevent a quorum or has veto power. The SBA considers stock options, convertible securities, and agreements to merge to have present effect on the power to control. That goes to the second point. And then the third test is affiliation based on management. This basically means that affiliation arises where a CEO or other person who manages the business also controls the management of another business, or where the individual or entity controls the board of directors, also controls the board of directors of another concern. Those would be considered affiliated entities. Finally, there can be affiliation based on identity of interest, and that's where they're close individuals, close relatives, with identical or substantially identical business or economic interests. So those are just rules to be aware of when determining whether a business meets the 500 employee threshold. And the SBA has clarified in its recent Q&A that it's up to the borrower to determine whether any affiliates must be counted towards that 500 employee total, and lenders are allowed to rely on the borrower's employee count and disclosures of the affiliate related to that. Just a final note on eligibility, borrowers have to make certain certifications on their applications, and they're listed here on the slides. I won't go into too much detail, but just wanted you all to be aware that that's kind of the final step in terms of being eligible of making these certifications there. So the next question is, what are the loan terms? Some of this has just recently come into focus, as Robert stated earlier, but what we know now is that no collateral or guarantee is required during the covered period, which is February 15th through June 30th. The portion of the loan that is not forgiven will bear a 1% interest rate over 2 years. The loan payments, including principal, interest, and fees, will be deferred for 6 months starting on the date of disbursement, and they're 100% backed by the U.S. government. Finally, there are fees available, and those will be based on the balance of the loan at the time of final disbursement, and they're based on loan amount, and they range from 1% to 5% depending on the size of the loan. Tabitha, will you go to the next slide, which kind of gives you a sense of the fees there. So next, how may the money be used? The Act specifically states that money may be used for any of the following purposes. So one is payroll cost, mortgage interest payments, rent, utilities, group health care benefits, and insurance premiums, and interest on any other debt obligation that was incurred prior to February 15, 2020. As Blake will explain, not all of those reasons will be forgivable, but they are all approved uses for the funds. So in order to determine how much money you can borrow under the program, you take the business's average monthly payroll during the previous year, and you multiply it by 2.5, up to $10 million. The SBA just announced that borrowers can either use the 12-month look back, or they can just use average monthly payroll from calendar year 2019, if that's easier. If a business was not operating prior to June 30th, 2019, then you use the average monthly payroll for January and February 2020, and there's also a different calculation for seasonal employers. So probably equally important is what is not included in payroll cost. So the first thing is employee compensation is capped at $100,000. There was kind of a lot of outstanding questions about this point, and SBA issued some guidance just yesterday that did provide some clarity. So they explained that this exclusion applies only to cash compensation. So you would not have to exclude non-cash benefits over $100,000. So things such as employer contributions to defined benefit plans or payment of employee benefits, those would not be included in this cap. The second thing that's excluded would be the employer share of payroll taxes during the covered period, and wages paid under the Families First Coronavirus Response Act's recent paid sick leave provisions. Those are not included as payroll because they are covered under a separate tax credit. The SBA also clarified recently that payments to independent contractors by employers would not be included either under the Act. So I'll turn it over to Blake at this point to talk about forgiveness.
Thanks, Katie. But before I talk about forgiveness, I want to touch on this briefly about existing SBA loans. The question is, do my existing SBA loans qualify for any kind of assistance? And the answer to that question is yes. Existing SBA loans are eligible for deferral up to 1 year. In addition, SBA is required to pay the principal, interest, and any associated fees for 6 months, beginning with the next payment due date. So what this means is if you defer your existing SBA loan for a year, then SBA would begin making those 6 months worth of payments at the end of that first year. Tal, can we go to the next slide? Another topic just to touch on briefly is the interplay with the PPP loans and the EIDL loans. The regulations that came out last Thursday discussed this in detail, and what they effectively said is if you take out an EIDL loan between January 31st through April 3rd to cover costs other than payroll, rent expenses, mortgage interest, interest on debt incurred prior to the cover period, or utilities, then you can still apply for a PPP loan. So if you take out an EIDL loan between January 31st and April 3rd, and you use it to cover things that are not authorized uses of the PPP loan, then you can still take out the EIDL. If you did use your EIDL loan for payroll costs, then the regulations require you to use your PPP loan to refinance your EIDL loan. And proceeds from any advance up to $10,000 on the EIDL loan will be deducted from the loan forgiveness amount of the PPP loan. So just to clarify, that initial $10,000 you get under the EIDL program is automatically forgiven, but that's going to reduce your forgivable amount on the PPP loan. So now into loan forgiveness. So the loan, including interest, is eligible for forgiveness only to the extent that you use the proceeds to cover rent, utilities, and payroll costs during the 8-week period following the date of the loan. Recently, last Thursday in the regulations, Treasury added another rule to that to say that 75% of the proceeds must be used for payroll expenses. Now, what's unclear is whether or not, if you don't meet that requirement, does that mean the entire loan is unforgivable or just the portion that wasn't used for payroll costs? We're waiting on further guidance on that point. Right now, that's just really unclear. So your eligible amount for forgiveness is also reduced in two situations. The first is if the borrower furloughs or lays off employees. The second is if the employer reduces the salary of any employee who earned less than $100,000 during 2019 by 25% or more. So if the borrower furloughs or lays off employees, the amount eligible for forgiveness is going to be reduced in proportion to the reduction in full-time equivalent employees from February 15th to June 30th, as compared to either the borrower gets to choose the average number of full-time equivalent employees per month during 2019, or the average number of full-time equivalent employees per month from February 15th, 2019 to June 30th, 2019. And this calculation is going to be different for seasonal employees. So I just said a lot there, so this is easier just to take it from an example. So if you had an average of 100 full-time equivalent employees per month during 2019, but only employed 25 full-time equivalent employees per month during February and June 2020, then the amount eligible for forgiveness is going to be reduced by 75%. How's the backup one? Now there's an exception to this rule, and that's if you eliminate the reduction no later than June 30th, 2020. If you do that, so using the same facts as the previous example, but the employer rehires all of the employees that were either furloughed or terminated on June 29th, 2020. Because the employer eliminated this reduction by June 30th, then the forgivable amount is not going to be reduced by the reduction in employees. And again, there's a second situation in where your forgivable amount is going to be reduced, and that is if you reduce the salary of any employee who earned less than $100,000 during 2019 by 25% or more. And so this is going to result in a dollar-for-dollar reduction in the forgivable amount. So how is the forgiven loan amount treated for income tax purposes? It's going to be excluded from taxable income. Documentation required to receive loan forgiveness. We're still waiting on additional regulations. We think there's going to be some more requirements as this thing progresses, but right now, based on the Act, we know that the borrower must provide documentation to establish the forgivable amount is true and correct, and they must certify that the forgiveness requested was used to retain employees, make mortgage interest payments, rent payments, or utility payments, and also interest payments on debts that were incurred prior to the covered period. Borrower must also provide documentation such as payroll tax filings, canceled checks, and other payment documents as the SBA may require. Next
okay,
slide.
Tabitha. Yeah, go to the next one there.
Oh,
So,
sorry, I guess I'm going to hand this off to Robert.
Okay, thanks, Blake. So as I mentioned when we first got started, just wanted to touch on what we're seeing as frequently asked questions, and as I mentioned also with the guidance that the SBA issued late yesterday, you know, we, like I think most people, will get into a position where we feel like we're comfortable with an answer to something that really is not addressed anywhere else, and then the SBA comes out and kind of throws a curveball at it. and so I'm going to talk through a couple of those. I had a client call earlier today, a bank client that I spoke with that indicated that on a call with the ABA this morning that there were a handful of issues dealing with the most fundamental one, which is loan documentation and what do we use to pay for these loans with, affiliation questions, and another big question we're getting is loans to insiders, for example, loans by a lender to a business that the lender's officer may own interest in, or director more often, what you see. So we're awaiting guidance on some of those types of questions. But just to kind of talk through some things, as Blake mentioned, the loan forgiveness, obviously a very important part of this whole thing, and the calculation itself, we are anticipating that over the next few weeks, most likely we'll receive guidance on a lot of the open questions regarding this. But if you walk through the calculation of the forgiveness amount as it's defined in the law, I think it's clear that the purpose is that the borrower be forgiven principal and interest, but it's not exactly clear the way the wording is. So we're hopeful for some guidance on that. From a timing standpoint, the interim rule that was issued last week indicates that banks can begin asking or requesting advance payoffs, essentially, or advance purchases by the SBA after week 7 of the 8-week covered period of any particular loan. The law is actually fairly detailed, as is the rule regarding what a bank or what a borrower is required to submit to a bank, and then the bank has to verify or confirm receipt of in order to request forgiveness. But again, we think we'll get some more information on that hopefully pretty soon. And you probably all heard yesterday that the Fed indicated it intends to provide liquidity to banks. I would think that would be in the form of just purchases of these loans once they've been funded, so that banks have capital coming back in that they could hopefully redeploy. So that's something to watch out for as well. Next slide, Tabitha. So one of the common questions is payment of deferred costs. So as was described earlier, when a borrower takes out one of these loans, the 8-week period starts to run from the time the loan is made as it's drafted. And there's some questions regarding that. But one of the things we keep getting asked is, well, if I have, as many businesses probably will do, is to kind of delay some payments, whether it be rent or utilities or payroll or whatever, until the loan is funded, which you would expect to see. And are those permissible costs if they're deferred payments essentially, and we turn and pay them with loan proceeds once it's funded? Are those permissible on the back end as far as forgiveness? And the way that the statute reads, it's quote costs incurred and payments made during that 8-week period. So again, subject to anything the SBA may come out with on this tomorrow, a payment made during the 8-week period, even if for prior payroll, for example, or prior rent payment or whatever it might be, we feel like that is within the language in the Act and would be a permissible use of those funds. We are advising all of our borrower clients and then advising all of our bank clients that separate accounts be set up for loan proceeds, which may seem pretty simple, but again, on the forgiveness end, on the back end of this thing, the tracking of payments during the covered period, how those funds were used for the permissible purposes for forgiveness is obviously very important. So we think that streamlines that to quite an extent. The loan application itself, I'm sure everyone saw the initial application that came out, I guess my days run together, but about a week ago, and then a final application was issued late in the week. In the frequently asked questions that were issued that I'll talk about, SBA confirmed that you can use either of the two applications and you're in good shape. And so if you are a borrower or represent a borrower that has already submitted an application and they submitted the initial one, according to the SBA, that is fine. There are some changes between those two applications. If you looked at them, particularly question 3, which references whether or not either the borrower applicant or a 20% owner of the borrower owns an interest in any other business. The initial application referenced affiliates, so we assumed and took that to mean It included only another entity that was an affiliate under the regulation, which is a defined term and basically means 50% ownership, essentially. But the final application did not include that. And so what we have done with clients is, or have advised, is that to ensure that we're complying with the request in the application, let's be as broad as we can on that addendum A, which is referenced in that question number 3, just to disclose any other business that, again, the borrower or an owner, a 20% owner, may have an interest in. And we prepared just kind of a form of addendum for that to cover, even as broadly as an investment account that some owner may hold, a small interest in a number of different publicly traded companies. We just had a kind of a catch-all disclosure for that sort of thing that we've advised clients to use. Another common question we're getting is guaranteed payments and then how that works with net earnings from self-employment. For tax purposes, guaranteed payments are defined within net earnings from self-employment, so we're comfortable that is within payroll costs. For a partner that may separately apply for the program. A related question we're getting is S corporation pass-through income, whether or not that qualifies. My view on it is that it does not, because it's not net earnings from self-employment. Pass-through income from an S corp is not net earnings from self-employment. So an S corporation owner that also takes a salary would be entitled, obviously, to payroll costs to the extent of that salary, or the corporation would. But we've not believed the S corp pass-through itself qualifies as net earnings from self-employment, so it would not serve as a basis for payroll costs for purposes of this program. Next slide. Big question on loan documentation, as I mentioned earlier. I had an email from a client as we've been sitting here who says he was on a call with the SBA, and the SBA has confirmed for banks to move forward with their own loan documents, and that the SBA may have other requirements down the road. We had kind of assumed that would be the case, and had been working with bank clients on proper documentation for the loan, and have come up with a number of different provisions that we're suggesting they include in their loan documentation. One of those is just again, kind of a catch-all to say that if the SBA comes back and requires any further certifications, different types of forms, whatever it might be, that the borrower is certifying, they will sign those when the bank presents them for signature. So I guess a little bit of guidance, assuming that is the case, that we move forward for each bank just with their own loan documents to get these things documented and funded. The second item there, terms of loan payments for the remaining balance. So you're all aware that the Act and the interim rule provides parameters for the loan terms, essentially 1% rate, 2-year term, 6-month deferral. But there's the obvious question of what happens after the end of 6 months. Can we term it out from there? What are the parameters? The SBA has not issued anything regarding that we've seen. There have been a lot of rumors floating around, like every other aspect of this program. But what we are seeing most banks do is just from month 6 through 24, set it up as an equal amortization during that time period at the 1% rate, with the understanding that it will be, or the hope that it would all be forgiven anyway. To the extent it's not forgiven, if you had someone that had 75% of their loan forgiven, for example, and you have this remaining loan hanging out there, then obviously you have to have payment terms that would cover that. And so we've suggested to our bank clients as well to include a provision that there would be an adjustment to the amortization payments in the event that less than 100% is forgiven, and just to make that adjustment should be pretty simple. I mentioned loans to bank insiders. This has been a real hot topic the last couple of days. We've had questions from clients on this as well, and talked to a lot of different folks, and there's not a clear answer in that. The SBA regulations that have been around forever refer to kind of these insider loan transactions as not being appropriate, I guess you could say, in an SBA guaranteed loan. But there's been a lot of talk from some of the congressmen and folks here in Arkansas that that is not intended to apply in this case, and that a director loan, as long as it was proper under Reg O, then there would not be a problem with those through the Paycheck Protection Program. We're still hopeful to get some guidance on those because I know that some have already been submitted to SBA, and so we will certainly keep an eye on that and get anything circulated as soon as we hear something. So bank underwriting obligations, a lot of concern with the initial act regarding what obligation the banks have to verify payroll cost numbers and information that are submitted by borrowers. The frequently asked questions, again, we sent an alert out a little bit ago on that, but it's clear, I think, and becoming more clear that banks are required to do just a reasonable review of any information they're provided. But otherwise, it looks like the SBA is comfortable that, as Katie mentioned earlier, the certifications that the borrower will provide are sufficient for the bank to rely on and to move forward there. Just real quick, eligibility of churches, a lot of talk about that. It was clarified, as Katie mentioned. The eligibility of farmers has been a question we've had. There's not a specific exclusion for farmers either in the act or in the rule. It is a bit concerning that there have been so many questions about it, but I would just say, again, just on the face of the act and the rule and the eligibility criteria there, farmers would be eligible to participate in the program. I expect that there will be something clarifying that from the SBA soon, and I know that farmers are applying, certainly, so we'll let you know what we hear on that. The take and hold issue is one that someone described to me that way recently, but that's a situation we're running into, and I'm sure you all see, where oftentimes your physician or dental clients who cannot really operate right now, can't function as a business in many respects, and have had to lay off folks. Are they able to get approved for a loan but not have any funds taken out yet, so that the 8-week period does not yet begin to run on them? There's not anything in the law or in the rule that would prohibit that, but you could easily see some pushback on that. The problem obviously would be if I'm a dentist and I've had to terminate most all of my workforce, and I take out a loan this week and my 8-week period starts to run, but I don't have any patients coming in, then it's clear what the problem is there. And so hopefully we'll get some guidance on that. I know the question has been submitted to the SBA at various levels, again, without any approval yet or really statements one way or the other. The liability for misuse of loan funds. So in the rule, you probably saw that there's a provision there essentially referencing potential fraud claims if a borrower takes funds and misuses them. The four permissible uses, again, that Blake mentioned, essentially employee-related costs, interest on certain debts, rent, and utilities. As Blake also mentioned, 75%, at least 75% under the rule must be used for payroll. That's a certification that the borrower is required to make. So, a question comes up is can you take the money knowing that you don't plan to use it for one of those four purposes, or knowing that you intend to, or you would not intend to use at least 75% for payroll? It's a little unclear. If you knew that was the case, I suppose there may be an argument for fraud, although that's a very high level of proof for something like that. So that too is a little bit unclear. But it has, I think it's something we're seeing or hearing a lot about is the potential that businesses take out these loans for no other reason than to get a 1% loan for 2 years. And in a situation like that, it's obviously you would have a little more concern about something like that, in maybe not fraud, but there are various other types of civil and criminal penalties that may apply to a loan of this type. The question of related entities and who should submit the application, we get that question quite a bit. The affiliation issue or determination applies for the 500 employee, the size criteria, and so it certainly with related entities comes into play there from an affiliation standpoint. But if you think about how the law works and the loan amount is determined, it's based on payroll costs. And so our view has been, if you had a parent subsidiary situation, if each of those entities is running a payroll and has employees and that sort of thing, pays the payroll taxes and so forth that are required as of February 15th, then each entity should separately apply for a loan based on its own respective payroll. Because if you combined it and the parent applied for both entities, but then the parent did not spend all of the monies on payroll during the 8-week period, then technically you would not have complied with that aspect of the rule. So I would just say that's our read on it. I'm comfortable with that. You get a little less comfortable when you see things like the SBA issued yesterday on frequently asked questions, which go against some of what was in the interim rule. But for now, that certainly is the advice we've been giving our clients on who should apply for this. On the next slide, so this question, the first one there has come into focus a little bit better. The gross payroll versus net payroll question, if you read through the law, then you're aware that it's extremely poorly written, I would say, in terms of which, if any, taxes are taken out or netted out of payroll costs to get to that amount or that sum that you would multiply times 2.5 times. The frequently asked questions that were issued yesterday clarify that it is essentially gross as to employee taxes. So, for example, you would not have to back out. The big one we were concerned about was employee income tax withholdings. So that is included in payroll costs. It's not netted out. But then the calculation is said to be net of the employer's share of payroll taxes. I would say most people that I'd talked to, most accountants that were advising borrowers that I had spoken with, were not netting out employee withholdings, income tax withholdings at least. They may have been the others, but that was seemed to be such a far cry from what the intent of the statute was. I don't think anybody was really paying attention to it anyway. But that is some clarification there. The next two, just 401k deferrals and match, and then profit sharing plan contributions. I've had more than I would expect questions about whether or not you include deferrals or matches for 401k purposes or a profit sharing plan contribution. In my view, it's clear that that's a retirement payment, or I believe so, and so those would both be included under payroll costs for purposes of determining the amount. The frequently asked questions, just to talk through real quick that came out late yesterday. There were 17 or 18 questions. If you haven't had a chance to see it yet, the alert we sent out earlier has a link to it, so you can find it there. And certainly we can, if you have questions, we'll be happy to discuss those. But just to hit on a couple of things, again, there were 17 or 18 questions, and we picked out some that we felt were most pertinent, really, for this purposes of the discussion. The lender responsibility we talked about a minute ago, again, I think the rule started in this direction, and then the frequently asked questions took it even further, just to say that a lender's responsibility, again, is to perform kind of a good faith review of what they're being provided. It also clarifies that you can give more weight, essentially, to the better documentation or the quality of documentation, such as IRS or state tax filings and that sort of thing. I think is helpful. Also, I think Katie mentioned earlier, it's clear in the frequently asked questions now that lenders are permitted to rely on the borrower certifications regarding affiliate status and then number of employees, which of course is directly affected or impacted by that. Just to clarify again, the cap on the $100,000 of annual salary, this has probably created more confusion than any other issue related to this, but it's clear that it's cash compensation only, so other benefits, retirement benefits, health care, anything like that would also be able to be included even if it went above the cap. An interesting question we've had a couple of times is for an employer that leases employees. It's question number 10 in the frequently asked questions. And so if you think about that situation, oftentimes the employer is just paying a sum to a third party that has the employees, runs the payroll, and handles that aspect of it. And so the initial thought would be, well, that's a payment to an independent contractor essentially and not included in payroll costs. But the guidance does clarify that employer receives credit essentially for those amounts that are paid as payroll by the third party. So that's probably the appropriate finding there. Signatures on borrower's application. So if you recall on the application itself, there are certifications that not only the borrower makes, but also that 20% owners of the borrower have to make. And question 11 of the guidance confirms that the bank can rely on a single signature of someone authorized to act on behalf of the borrower. So that person is really certifying that the borrower agrees with certifications, as well as each 20% owner is essentially making those same statements and certifications. The question 14 is the time period for calculating payroll costs. So if you look at the law, the statute says you determine payroll costs based on essentially a 12-month look back. But if you looked at the application, you may have noted that they have a statement in there that it says something to the effect that most borrowers will use their 2019 calendar year payroll, which again is not what the law says. The frequently asked questions confirm that, notwithstanding that the SBA will allow a borrower to use either their amounts for 2019 calendar year or the actual 12-month look-back period prior to the date of the loan. So either one could be used there. And then there's also discussion in the guidance regarding the net versus gross payroll calculation that I mentioned, and just laying out the same way as far as how that works. And then lastly, even though the application changed, I think I mentioned earlier, but the frequently asked questions say if you've already submitted the old application, then banks are allowed to run with that and use it as the application for purposes of the Act and the loan program. So that's all the material we had prepared. We have received a number of questions emailed in beforehand, and so we will just kind of talk through some of these, and I'm not sure, Tabitha, if others are coming in, you can send them to us, and if we have time, we can get to those. But folks, let me read the first one. So it says, we have several employees who receive bi-monthly draws against their commission, and one of the bi-monthly checks includes the balance of their commission for the previous month. If their commissions drop more than 25%, will our loan still be forgiven? My initial thought on that would be that the 75% requirement is basically compared to the amount of the loan. So if you're not using 75% of it for payroll or employee related costs, then I think they would probably run the risk in this situation of having some portion of it not be forgiven. But the forgiveness aspect is it's a pro rata in terms of employees, and then it's just a dollar for dollar reduction on the 25% rule as far as how that comes into play. And then Blake, you want to take the next one?
Yes. The next question we have is, to what extent are companies seeking loans having to show their bottom line cash flow warrants the loan? I haven't had a single client whose banks asked them to show, to demonstrate that they are in need of a loan. So I would say at this point, I haven't seen that is a requirement. The next part of the question is, what will be asked down the road to be shown so the loan is forgiven? What the Act says is that, this is actually in the regulations that were issued last Thursday, that the banks will need substantiation in the form of, that receipt of payment to employees and any other documentation that the SBA may later require. So the expectation is we're going to see a list of these documents be provided by the SBA as far as what's required to substantiate loan forgiveness. But I would say we're telling clients now, to track where the money's going and to keep any receipts to be able to be prepared. Yes.
Yeah, I'm sorry. Yeah, and the first part of the question, I think the act is clear that there is no real immediate need you have to demonstrate from a financial perspective. It's more the uncertainty of the virus and just the general economic uncertainty that the act effectively assumes everyone's impacted by it and thus necessitates the loan. So, and then Katie, you want to take the next one?
Sure. The affiliation rules seem to apply only for determination of small business status. Has there been any speculation about the ability of affiliates to combine or use expenses across company lines to qualify for a greater level of forgiveness? This could be similar to filing on a consolidated basis, especially where one affiliate may bear expenses that are relevant to other companies. The first part of that is true, that the affiliation rules, certainly apply in determining whether a company meets the 500 employee threshold. In terms of getting a higher or a greater level of forgiveness based on combining affiliates, I have not seen that. I have not seen anything in the rules or statute that would suggest that was the case. And we have been telling people, as Robert alluded to really file based on the individual entity for whom the payroll is submitted. But Robert, do you have anything to add to that?
Yes, I have not seen anything that would lead to a thought that you could file it essentially on a consolidated basis that's referenced there. And again, there's not anything in the law or the rule that really reads that way or would provide for that. So I would agree. So the next one is since we have already had to cut down on employee staffing, can you go through your understanding of the rehiring and restoring wages clause? Is it saying that if I restore employment levels and weekly payroll totals by June 30, 2020 to the levels before February 15, 2020, that I will still receive full forgiveness of the payroll costs I incurred during the 8-week period, even if it hasn't met the 75% total of the loan? Let me say my thought, and then Blake, if you would tell me what you think on this one. I think the 75% loan requirement, let me back up. The June 30th date, if you restore those employees or same level of employment at least by June 30th, I would agree that reduction is ignored in applying the full-time equivalent employee test and then the reduction in pay test. I'm not yet clear on how, I don't think there is any clarity on how the 75% requirement impacts, works with that, because those are really two separate requirements, and we really don't know the full ramifications of the 75% requirement on use of the loan for payroll costs.
Yes,
Blake,
Robert, I would agree with that.
Okay.
Yes, I would agree with that. It's really two different requirements. The way I kind of view it is you have this first threshold of you take your total loan amount and reduce it by any amounts that weren't used for those forgivable items. And I think that 75% threshold really plays into that first calculation. Okay, so once you get past that first calculation, you then reduce the forgivable amount even more to the extent you've had a reduction in employees. And of course, like I mentioned in the earlier part of the presentation, if you eliminate that reduction prior to June 30th, then that reduction resulting from a reduction in employees is not going to apply. It is the way we understand it.
Yeah. So the next question, if my restaurant reopens during the 8-week period, since cash tips and equivalents are part of payroll costs for the loan, how would those be handled on loan forgiveness if they're being paid for by guest gratuity instead of from loan proceeds once the store opens? Blake, you have a thought on that?
Yes, I think you would have to, again, your loan, the amount eligible for forgiveness is only going to be, you're not going to get the benefit of those.
Yeah, I agree. I mean, it's what the employer, the borrower, pays for payroll costs during that period. So I would agree you wouldn't get benefit of guest gratuity.
Oh. See, the next question is, how do we now file for guaranteed payments? We file under the I think the next question is asking, are guaranteed payments included in the payroll calculation of a partnership? And the position we've been taking, as Robert explained, is since guaranteed payments are considered income from self-employment, that the partnership would not get the benefit of including those guaranteed payments in its payroll cost calculation. But we're telling individual partners that they can apply for a loan as an independent contractor to the extent they've received guaranteed payments.
Yeah. I'd say the next one we have, I've been told that the $10,000 loan advance grant and any portion of the Paycheck Protection Program that is forgiven will not be counted as taxable income. Is that correct? It certainly is with the Paycheck Protection piece of it. Blake or Katie, do you all on the $10,000 advance? That's not something I've looked at, honestly.
My understanding is that the $10,000 loan advance would apply to the disaster loans, and it is forgiven, and it's treated the same way that the forgivable portion of the PPP loans would be. So I believe the answer is yes, it's forgivable. It will not be, taxable.
Okay.
And I guess to answer one general question that we've gotten in a lot of the messages is that Tabitha will be sending around a video of the program once it's over to everybody who's participated.
And guys, I am just real quick. I'm trying to look at some of the questions that have been submitted. Would a partner apply for a PPP loan separate from the partnership on his self-employment earnings? Yes, it would be the answer to that one. That the partner would have to apply separately for the PPP loan. Again, because it's net earnings from self-employment, whether guaranteed payment or distributive share from the partnership. Question: Are you hearing from your banking clients they're already funding these loans? If so, are they doing it with the understanding or documentation the borrower will comply with future requests from the bank? Should SBA Guidance come out later requesting something different? So the answer to that is, as of the time we got on this call, no. I had not had any bank client that I was aware of at least fund a loan, and we all had the concern that other things may come from the SBA. I've gotten a number of emails while we've been on this call, and I think I think people may start going ahead and funding, because it sounds like from a couple of sources, as I said, I think I'm hearing that SBA is telling banks to move forward with their own loan documentation. As far as what language we have in these loan documents, so what we have provided to clients is a provision that is really just as described there, that the borrower is agreeing to provide, sign, acknowledge, et cetera, anything that we are required to get from them, as the lender, to comply with the CARES Act or any SBA rule or anything like that. And then other provisions, just an intention paragraph that everything under this is intended to comply with the CARES Act. And then I think it's important to have language in there regarding if there's not full forgiveness of a loan, how that's going to be handled. Another question: if we pay our safe harbor match at year end, what amounts can we submit for the loan? You guys, let me know if you think differently, but if a safe harbor match is paid at year end, if you're using a 12-month look back, that would be included in the sum that you divide by 12 to get a average monthly payroll. So I think it would be included. And then there's a question, just want to make sure I'm understanding, if no one's payroll is over $100,000, no one is laid off, or furloughed, and they pay over 75% in payroll and the rest in rent and utilities, then all of the loan proceeds will be forgiven. I think so. Katie or Blake?
I would add to that.
Okay.
I would add to that, there's also the requirement that no one's salary is reduced by more than 25%. So if you have all those elements, then that's correct. All the loan proceeds would be forgiven.
Okay. There's another one. If an independent contractor applies based on net Schedule C earnings, how would payroll be calculated for the 75% loan forgiveness if they pay themselves but have no employees? I mean, I think in that case, if they are the only, they are the only employee, so to speak, as an independent contractor, but they would be using the funds, presumably 75% for what our payroll costs. So I think that would be full forgiveness if you solely use the funds for that purpose. You guys have any thought on that?
I agree with that. Yeah, that makes sense to me.
There's a question, can you go over the layoff or furlough scenario one more time? Blake, do you mind doing that, just as far as if you lay folks off and how bring people back by June 30th, how that factors in, and then two, the calculation on the potential partial forgiveness if you've not maintained full employment.
Yeah, so the way it works is if you have a reduction in employees, let's say of 25%, then the amount eligible for forgiveness is going to be reduced by 25%. However, if you increase your employment numbers to what they were prior to the covered period, in other words, you eliminate that disparity in your employment before June 30th, then you're not going to be penalized for reducing your employees during that 8-week period, or that period from June 15th to June 30th.
Okay. Say one more question. I think that's it. Can landlords of apartment complexes with payroll apply for these loans as an active business? If so, then the affiliation rules will be applied only for the purposes of the 500 employee limit. It says some authors say to count the number of tenants for the 500 limit. That doesn't make sense to me. Yeah, that doesn't make sense to me either. I haven't seen anything that would. I guess I hadn't had that question specifically. There's nothing in the law that would say you would count anything other than just employees, both full and part-time, for the size requirement. I have not looked into the issue because your question says, is that an active business? If you're a landlord at an apartment complex, I assume that it would be, but I'm not certain. I'm not seeing anything that would say otherwise, but we'd have to confirm that. If an employee resigned on their own in early March, can they be excluded from the calculation to determine if all employees are retained? You would look at, as Blake said earlier, you compare the 8-week period of employment, what your employment of full-time employees looks like. You compare that back to either essentially what is the first half of 19, or if it's better for the borrower, you can look at January, February of this year. So there's some workarounds there on that kind of thing. Well, folks, I think that's we're happy to take questions offline. If anyone has any others, we're available, and obviously trying to stay on top of all this stuff. And so we appreciate everybody being available today and joining in, and look forward to talking to you all soon. Thank you.
And I'm just going to add real quick that the questions that were asked that we didn't get to answer, I will send an email with those answers.
Sounds good. All right. Thanks, everybody.